Hi, I'm Jeff Segal, founder and CEO of Medical Justice and eMerit. We're here today with our general counsel, Mike Sacopulos. We've had several doctors connect with us saying that they don't take insurance, which means that they don't have to worry about HIPAA. Is that correct? Are they actually immune from any of the challenges associated with HIPAA?
Being Greek, you always hate to be the messenger with the bad news. But I've got to tell you that you still have to have a compliance program in effect, even if you say HIPAA doesn't comply, because you're practicing in a state with privacy laws. And those privacy laws, when the courts look at whether you met them or not, those courts are now using HIPAA as the general standard. So it kind of comes in the back door, and you're very much at risk if you haven't made some kind of effort that you can show links up to requirements under HIPAA.
Now, my understanding is that HIPAA attempts to be a balancing act. It's not designed to shut down a practice. It's designed to protect a patient's protected health information. But at the same time, care needs to be delivered, the operations of an office needs to continue forward, and insurance companies need to pay for services that were rendered. Some practices have said they can take no action unless a patient is given written authorization to do almost anything. Can you talk about some of the exceptions where you actually do not need the patient's approval to actually get something done?
There are a handful. Perhaps the saddest example I could give you was the Pulse nightclub shooting, where a number of people were shot, were taken to emergency rooms. Family members were calling in to see if their loved one was in the emergency room, and they were being told wholesale, we can't give out any information about our patients. The Office of Civil Rights reacted very quickly to that after the fact, making clear that in these kind of emergency situations that information can be shared with family.
If a doctor wants to connect with a referring doctor to get information from that referring doctor, does the patient need to sign a HIPAA release to get that information, or can a doctor actually speak with the referring doctor directly and learn all the things he needs to about that patient?
Can definitely speak directly with the referring physician and provide information to the referring physician, unless for some odd reason the patient has specifically said, do not share my information with anyone. But in the general course of treatment, when you're referring a patient on, yes, you can provide information to the referral source.
And what about an insurance company? If a patient comes in and presents their Blue Cross card, is it assumed that you can then submit a claim on their behalf or send information to the insurance company to get paid? Or do you need the patient then to fill out reams of paperwork to accomplish that?
No, in a move of surprising efficiency, that was excluded from the rules. If it's in the scope of getting paid for the services that you rendered, there's no specific requirement there. So you may go ahead and bill third-party payers.
Who knew? That's great news. For more information or to join our mailing list, sign up at info@medicaljustice.com.